Welcome to this competition law podcast in which I'm joined by Ben Keane. Ben runs a specialist European law, competition and media law practice in Brussels called Keane Legal. Ben has considerable experience dealing with the application of competition law rules to the sports sector and has acted for a number of sports governing bodies and organisations and on competition law issues before the European Commission and the European courts. But I wanted to start, Ben, by perhaps asking an obvious question, obvious to some at least. What do we mean by competition in sports law? Is sport any different from any other sector of the economy?
Well, I think the starting point should be that competition law should not be confused with the laws of the game in sport. Competition law regulates the manner in which companies compete on the market. The basic principles of European competition law are set out in the Treaty on the Functioning of the European Union. Article 101 of the treaty prohibits companies from colluding together to restrict competition, for example, by forming a cartel which fixes prices. Article 102 of the treaty prohibits companies in a dominant market position, i.e. those companies which are in a very strong position, from abusing their position and eliminating competition. Now, these rules are strictly enforced by the European Commission and by national competition authorities in the EU member states. Companies can be fined up to 10% of their annual turnover if they are found to have infringed the competition rules. So, to a certain extent, competition law applies to sports organisations and companies in the same way as normal companies on the market. For example, the European Commission could launch a cartel investigation against football clubs if they got together to fix the prices of the value of replica shirts. However, sport is certainly special, and its unique characteristics have been taken into account in two specific areas. Firstly, in the commercial sphere, and secondly, in the regulatory sphere. Now, in the commercial sphere, clubs, leagues and sports competition organisers have to cooperate to create a sports product. For example, the FA Premier League requires 20 independent football clubs to form a league in order to have an exciting sports product to sell to the consumer. Without this cooperation, there would be no sports product. And this contrasts with the position of other economic sectors where companies who are competing with each other would not normally be required to cooperate with each other to form a product. Indeed, sport is even more peculiar because teams depend on each other to be strong competitive forces in order to be able to cooperate together. For example, Liverpool needs Manchester United, as much as they might not like it, to be able to form an exciting match as part of the FA Premier League or any other football competition that they may be in. The other aspect of this is the regulatory sphere. Governing bodies for sports have to oversee the enforcement of regulatory rules, such as anti-doping rules. Competition law can apply to the manner in which they exercise their regulatory roles and to ensure that they do not abuse their regulatory positions.
If we stay with the commercial sphere first then, Ben, how do competition rules apply to the sale of media rights to sports competitions, for example?
This area has been developed in the last number of years by the European Commission in a number of leading cases, the most famous of which involved the UEFA Champions League, but there were a number of others involving, for example, Formula 1, the FA Premier League and the German Bundesliga. Now, starting with the basic principles, Article 101.1 of the treaty prohibits an agreement between undertakings or an association of undertakings which has as its object or effect the prevention, restriction or distortion of competition and which affects trade between EU member states. Clubs are undertakings for the purposes of Article 101 in that they carry out economic activities when they are selling the media rights to television broadcasters. They are not in any way providing a social role by this economic activity. In this respect, football leagues or national associations which sell media rights are therefore considered as associations of undertakings for the purposes of the treaty rules. So, for example, in the FA Premier League case, the Commission stated that the clubs were undertakings and therefore the FA Premier League was an association of undertakings when selling their media rights.
Ben, is it not arguable to say that the clubs are acting really as a single entity rather than multiple undertakings when selling rights through a league and therefore aren't subject to competition rules at all?
Well, I think that's a very interesting point. In order for the competition rules to apply, there must be an agreement between at least two undertakings or a decision of an association of undertakings. The undertakings in question must be independent. So if we look at a normal company which has a parent company and a subsidiary, they are not caught by the competition rules under Article 101 because they are treated as being part of the same undertaking or company for the purposes of competition law. The argument has been made that sports leagues are similar to parent-subsidiary company situations because the clubs need each other in order to be able to create the competition in question. However, the European Commission took the view that each club is an independent owner of media rights in the league, and therefore the league is an association of undertakings for this purpose. The issue of whether a sports league is a single entity was considered in detail by the US Supreme Court in the 2010 American Needle case. This concerned the sale of trademark logos by the NFL teams through a single sales supplier. The question before the US courts was whether this was a single company likely to fall outside the scope of the US antitrust rules, or whether it was the action of many companies together acting in collaboration, which actually restricted competition by eliminating them as competitors for the same logos. Now, the US Supreme Court stated that to a company making baseball caps, the NFL teams are, and I quote, potentially competing suppliers of valuable trademarks. As a result, the US Supreme Court ruled that decisions by NFL teams to license their separately owned trademarks collectively to only one vendor are decisions that deprive the marketplace of independent centres of decision making. So this brings us to, if we look at the position between the EU and US, I think to a broad consensus of how we approach this issue. The collaboration between clubs and leagues is likely to be caught by antitrust rules and is not exempt on the basis that it is a single entity.
So if the league's agreements are caught under Article 101.1, how are the rights then sold in line with competition rules?
Well, thankfully for them, there is a get-out clause. Article 101.3 states that an agreement will be considered as being justified where the benefits of the restrictive agreement to consumers outweigh any detrimental effects on trade or competition. Now, the Commission has set out a number of elements it will take into consideration when making an assessment of the benefits of collective selling of media rights by sports leagues. Firstly, it recognises that having a single point of sale is beneficial to broadcasters. Instead of having to look at doing a deal with 20 different football clubs, the broadcasters are able to do a deal with a single supplier. This also enables the broadcasters to plan their schedules for an entire season, because if you're reliant on one club to provide your rights, you may not necessarily get their competitor in a particular match to sign up to your broadcaster. This, in fact, has been a problem in a number of member states, such as Spain. So the single point of sale allows an organiser of a league to control both the branding and planning of the entire season, and it enables the broadcasters to have a certain amount of stability in what they're receiving. The second element that the Commission looked at was the exclusivity of the agreements. It, on the one hand, said exclusivity was permitted, and on the other said that having too long exclusivity could be a problem. The compromise they came to was that 3-year exclusive agreements for the sale of media rights would be acceptable. And the third interesting element that the Commission asked for was that the rights be sold in packages. Now, what do we mean by this? For example, in a football league, there may be between 120 to maybe 140 or so football matches over the course of the entire season. Now, if all of those football matches are sold in one lump, it may be that only one broadcaster will have sufficient financial firepower in order to be able to purchase those rights. Instead, if the rights are cut up into a number of packages, let's say 6 or 7 packages of 20 available matches, this may enable a number of broadcasters to be able to compete for the rights and to be able to show the rights, which is in fact something that has happened across a number of European member states. If we look at, for example, the FA Premier League, it is now available on a number of broadcasters and not just a single broadcaster. So these broad rules have been set out by the European Commission and have now been followed in a number of decisions by the national competition authorities. For example, the Bundesliga was recently allowed to go ahead with the sale of its rights in Germany by the German competition authority, more or less on the same parameters as those set out in previous decisions.
Does this mean, Ben, that all forms of collaboration are therefore likely to be exempted from the treaty?
Not necessarily. Again, if we look at the activity concerned, this is where the important distinction can be made. While it makes sense that coordination will be required in areas such as creating the broadcast to matches of a league, it may not be justified in other areas. For example, the sale of replica shirts. A competition authority is likely to consider it not necessary for the football clubs to get together in order to be able to sell their replica shirts. There seems no logical reason why they should get together and agree a single price for the sale of their replica shirts. So cooperation is likely to be permitted only where it is indispensable to improving the production of the sports product. Where this is not the case, the rules may kick in and the relevant agreement may not be permitted.
All right then, Ben. Well, if we take it as read that rights can be sold exclusively to a particular broadcaster in a particular country, are those broadcasters then able to prevent broadcasters from, say, other EU member states which infringe their rights?
Well, I think that's a very interesting question, and it is one which was at the heart of the QC Leisure and Murphy cases. These cases, as you may know, concern the use of foreign decoder cards imported from Greece to show FA Premier League matches in pubs in the United Kingdom. If we take the Karen Murphy case, well, this concerned a publican in Portsmouth who purchased a Greek decoder device to show Greek broadcasts of FA Premier League football matches in her pub, the Red, White and Blue in Portsmouth, if you ever want to go there. However, the Greek broadcaster was required by the Premier League to encrypt the signal and was prohibited from selling its decoder cards and devices outside of the Greek territory. As a result, the decoder devices were supplied to Murphy by intermediaries, contrary to these contractual provisions. Murphy's decoder was registered for personal use at a Greek address and not for commercial use in the United Kingdom. As the decoder card was only registered for private use, it obviously cost a lot less than a decoder card for commercial use, which allow pubs in the UK to show the FA Premier League's exclusive rights.
Well, that devaluation in the value of the rights must have been of some concern to the Premier League. What did it do to protect its rights?
Well, this is where the origins of the case lie. In the first instance, criminal proceedings were brought against Karen Murphy on the basis that her use of the decoder device in the United Kingdom amounted to an infringement of its intellectual property rights. It was also claimed that the use of the unauthorised decoder card was contrary to the European Directive on Conditional Access. In addition, civil law proceedings were brought against a number of importers of the decoder card devices, such as the company called QC Leisure and a number of others. Now, in their defence, the defendant parties raised competition law arguments, and in particular they argued that the FA Premier League granted its broadcasters absolute territorial protection. Under competition rules, they claimed that this absolute territorial restriction was contrary to European competition law. In addition, they claimed that the national laws enforcing the intellectual property rights infringed the EU internal market rules on the free movement of goods and services. The English courts hearing the cases referred a number of very complex cases to the European Court of Justice for a preliminary ruling to determine whether the FA Premier League was able to enforce its rights. The European Court of Justice, after a lengthy time of deliberation, finally reached its judgment in October 2011. And this judgment can be broken down into three separate but interlinked issues. Firstly, the EU internal market rules on free movement of services. Secondly, competition law. And thirdly, the enforcement of intellectual property rights.
Well, if we can start with the first of those, what were the issues that arose in respect to the free movement rules?
Well, the FA Premier League claimed that the decoder device used by Karen Murphy was an illicit decoder device prohibited by the EU Conditional Access Directive because essentially the decoder was being used in an unauthorised manner. Murphy and QC Leisure, in their defence, claimed that this was an incorrect interpretation of the Conditional Access Directive, and any attempt to apply it in this manner was contrary to the free movement of goods and services. Now, the ECJ agreed with Murphy and QC Leisure on the basis that a decoder device must be manufactured, manipulated, adapted or adjusted without the authorisation of the service provider in order for it to be, quote, an illicit device. Simply using it in a pub did not fall into that category in its view. The ECJ also ruled that any national law which prevented the unauthorised use of a decoder on this basis would amount to an unjustified breach of the free movement rules on goods and services. This element of the European Court's ruling means that it is not illegal to import a decoder device from one member state of the EU into another member state.
What were the competition issues that arose in the case then, Ben? What was the second element of the judgment?
Well, the second element related to the territorial licensing system used by the FA Premier League to sell the rights of its matches, and indeed it was one used by a number of sports leagues. Murphy and QC Leisure argued that the territorial restrictions imposed upon the Premier League's broadcasters infringed competition law by object, as they prevented any form of parallel trade or grey market trading in the receipt of broadcasting services. This is something that we see normally in the area of goods. For example, perfumes being traded from a country where they are sold cheaply into a country where they are sold for a higher price. Essentially, the argument that they raised was that this logic applied to broadcasting services. On the other side of the argument was the FA Premier League, who relied upon a 1980s judgment of the European Court of Justice in relation to the sale of films. In the Codatel 2 case, the ECJ held that a sole licence to show a film and prevent others from showing it at the same time did not have the object of restricting competition. The ECJ at the time considered that such licences would only be prohibited if they had a harmful effect on competition, for example as a result of a long period of exclusivity. The European Court of Justice in its ruling last October distinguished between the protection for the broadcasting rights and the ancillary protection provided to prevent the importation of the decoder devices. On the one hand, the European Court of Justice was unequivocal in its decision to uphold the principles established previously in the Codatel 2 case. In particular, the European Court of Justice stated, "As regards license agreements in respect of intellectual property rights, it is apparent from the Court's case law that the mere fact that the right holder has granted to a sole licensee the exclusive right to broadcast protected subject matter from a member state, and consequently to prohibit its transmission by others during a specified period, is not sufficient to justify the finding that such an agreement has an anti-competitive object." What this means is that the European Court of Justice recognised that it was legitimate for the FA Premier League to appoint a broadcaster on an exclusive basis in a particular territory. On the other hand, the European Court of Justice considered that the additional contractual obligations which prevented the supply of decoder devices by a broadcaster outside of its licensed territory eliminated all competition between broadcasters and resulted in those broadcasters essentially being given absolute territorial protection. Such contractual obligations, the European Court of Justice stated, had the object of restricting competition. Essentially, the European Court of Justice stated here that it did not want these agreements to resurrect national partitions between markets, thereby frustrating the EU single market. Now, the European Court of Justice also looked at very briefly whether or not the restrictions on competition may be outweighed to provide benefits to the consumer. However, the European Court of Justice referred to its reasoning on the issue relating to free movement to find that there was, in fact, not a benefit to the consumer that could outweigh the restrictions. For example, the European Court of Justice in that part of the judgment said it should be possible in selling the rights to take into account the actual and potential audience to whom you are selling the rights to. And in the European Court of Justice's view, it should have been possible for the FA Premier League to anticipate a certain amount of overspill of its rights into other markets. However, it also said that less restrictive elements to be able to protect the rights could have been put in place. For example, it may have been possible to put in language parameters into the contract to require a Greek broadcaster to only broadcast the matches in Greek. So those are the elements that may allow a certain amount of restrictive elements to the agreements without necessarily frustrating all forms of competition.
It would seem, Ben, that Murphy and QC Leisure were successful in many respects. What effect did the ECJ judgment have on the intellectual property rights of the broadcasters?
Well, I think to Murphy and QC Leisure, this part of the judgment is the sting in the tail. The European Court of Justice was confronted with a number of very detailed questions relating to intellectual property rights that pertain to broadcast of sports events. In essence, the European Court of Justice was asked whether the live broadcast of a football match was protected by intellectual property rights and whether such rights are infringed when the broadcast is communicated to the public. Now, looking at this question, the European Court of Justice said that the FA Premier League could not claim copyright in the football matches themselves because the rules of the game leave no room for creative freedom for the purposes of copyright. In other words, a football match, unlike a dramatic performance such as a play, is not protected by intellectual property rights. Consequently, the initial broadcast of the football match is not protected under EU intellectual property law. However, the ECJ found that the right holder can rely on the copyright which attaches to the works contained in the football match broadcast. In the Murphy case, the Premier League relied upon its copyright in the opening video sequence, the FA Premier League musical anthem, and various graphics shown throughout the match. Looking at the effect of those particular protected works, the European Court of Justice held that there was no infringement of those rights where the broadcast was being viewed for private purposes. This, the ECJ held, falls within the lawful use exception of the Copyright Directive. In contrast, the European Court of Justice considered that the transmission of the broadcast to the public, for example in a pub, constituted a communication to the public protected under the Copyright Directive, which required the permission of the right holder. If I may quote the relevant part of the judgment, the European Court of Justice stated, "The proprietor of a public house intentionally gives the customers present in that establishment access to a broadcast containing protected works via a television screen and speakers. Without his intervention, the customers cannot enjoy the works broadcast even though they are physically within the broadcast catchment area." In addition, the European Court of Justice said, "It must therefore be held that the proprietor of a public house effects a communication when he intentionally transmits broadcast works via a television screen and speakers to the customers present in that establishment." So the European Court of Justice, having found there was a communication to the public, then looked at whether this was of a commercial nature. And here the ruling of the European Court of Justice is interesting. It stated, "It is indisputable that the proprietor transmit the broadcast works in his public house in order to benefit therefrom, and that the transmission is liable to attract customers to whom the works are transmitted are of interest." What the court is saying is that if a pub shows football matches, it is likely to attract customers and therefore improve its custom. It is a commercial activity which falls within the Copyright Directive. So, taking these elements into account, what this means is that to a certain degree, the rights of the FA Premier League are still applicable when the football matches are shown in a pub, and it is still able to control whether or not publicans show those matches unless they receive permission to be able to broadcast them. This was the final element of the ruling, and the case was then referred back to the English courts for final adjudication.
Well, Ben, what happened in the next stage of the saga when the case returned to the United Kingdom?
Well, there's been two recent judgments before the English courts applying the ruling of the European Court of Justice. If I take Mrs. Murphy's case first of all, this was a criminal case, and it was unsurprising that the High Court quashed the conviction against Mrs. Murphy as a result of the ruling of the European Court of Justice. Turning to the QC Leisure case, here the High Court, dealing with the civil matters, issued a rather lengthy judgment relating to the ruling initially given by the European Court of Justice. It issued, for example, a declaration that the contractual provisions prohibiting the importation of the decoder devices infringed European competition law. The High Court also ruled that there were a number of rights at issue which were communicated to the public contrary to the express authorisation of the right holder. What this means is that the High Court recognised that there were certain rights which were pertaining to the broadcast which were still protected. And the High Court recognised that there is no such thing as an inferior right within the scope of intellectual property law. So what this means is that the anthem or the graphics may not be considered to be particularly important by the viewer, but as a matter of law, they have as much protection as any other form of intellectual property right, and the right holder is entitled to protect them in the way that they feel is appropriate. What the High Court decided to do was refer the matter of damages to the Patents Court relating to how much of an infringement should be construed to these rights.
So, Ben, going back to the key issue at hand, can you use foreign decoder cards to broadcast foreign matches in pubs?
Well, I think while the headlines were quick to come to that conclusion, the lawyers sitting down reading the judgment have come to another conclusion as reality has hit those involved. In particular, Mrs. Murphy's original objective of having the right to show the matches has failed so far. It is also noticeable that a number of the importers involved in the case, as well as a number of other high-profile importers of decoder cards, have ceased to supply decoder cards pending the outcome of the rights clearance issue. In other words, there is not sufficient clarity at the moment for them to be able to sell the cards without breaching the relevant rights. And indeed, the right holders have made a very strong point to say that they will continue to enforce their rights to the best of their ability.
Another issue entirely is, though, about watching foreign broadcasts at home, is it not?
Well, this is where, ironically, Mrs. Murphy may be in a worse position to her customers. It seems reasonably clear from the judgment that there is nothing to prevent private individuals from purchasing foreign decoder cards and bringing them back to the United Kingdom to watch matches. But in practice, this might have little real effect. The reality is that Mrs. Murphy purchased a residential card to be able to show it in a commercial setting. However, that residential card was obviously a lot cheaper than a commercial use decoder card. A normal resident in the United Kingdom is unlikely to find a huge price-saving difference between a decoder card, for example, to the rights of matches shown in Germany to those shown in the United Kingdom. So indeed, while the judgment has enabled private individuals to purchase decoder cards from other EU member states, they may not find the price savings sufficiently interesting to warrant watching the entire matches in Greek. This means that while expats who want to watch their home broadcast will benefit, in the long term there may be little practical difference to the market.
Does the QC Ledger judgment mean now, Ben, that many media licensing contracts are contrary to European competition law?
Needless to say, sports organisations have been watching this case with particular interests. As a result of the ruling, right holders still retain the right to sell their rights exclusively, and broadcasters can still be required to encrypt their signal. However, sports organisations may now pay particular attention to the enforcement of rights such as graphics, music, and other rights which are used throughout the broadcast rather than just the broadcast itself. It's rather ironic that one element of this judgment is to highlight the bits that we consider to be unimportant are now some of the most important elements of the actual broadcast. As regards other contractual provisions, it should still be possible for right holders to restrict their broadcasters from actively seeking consumers outside of its licensed territory. What we mean by this is that, for example, a Greek broadcaster may be prohibited from actively seeking customers in the United Kingdom to purchase its decoder cards. This is a standard element of other parts of European competition law. To a certain degree, one may ask whether this would be in any way effective, considering that it's likely that the decoder cards will come from third parties. Nonetheless, it provides an additional form of contractual security. And of course, the final element raised by the European Court of Justice was that there may be other features that one can attach to the license that will also strengthen the exclusivity. The most obvious one is that you could add a requirement that a broadcaster only broadcast the matches in the language of that broadcaster. If we take a German broadcaster, it may be possible to license the rights to English football matches in German only. This will make it less attractive to consumers in the United Kingdom unless they've got particularly good German. There's one final element that right holders may be able to do, which is to ensure that their overspill clauses are able to deal properly with the passive sales, i.e. those consumers who go out and purchase on their own volition the decoder cards. A proper overspill clause which allows for a certain amount of leakage should be able to deal properly with the passive sale element. And of course, the most sensible thing any right holder should do in their licensing agreement is ensure that they have a get-out clause. In other words, if there are any problematic provisions, it should be clear as a boilerplate clause that those clauses will not affect the legality of the rest of the agreement, because the last thing you want to do is find your entire agreement as void simply because you put in something that shouldn't be there.
Ben, I wonder whether the ruling means that sports organisations are now going to sell their rights on a pan-European basis rather than a member state basis.
This may well be one of the long-term consequences of the ruling. However, at the moment, there are not many broadcasters, indeed there may not be any, who will be willing and able to purchase the rights on a pan-European basis. In addition, any such broadcaster is likely to have to subcontract the rights to other broadcasters in EU member states, and then they may find the same problems arising simply at their level rather than the level of the right holders.
Is the judgment confined to the sports sector or even just the satellite television sector?
Well, I don't think there's any reason why the principles of the judgment should be just limited to the sports sector. Indeed, the case was followed very closely by a number of other creative industries.
So what then, Ben, are the effects of this ruling on those wider creative industries?
For the wider creative industry, the Murphy judgment does not spell the end of the territorial licensing system. It had initially been feared that the ruling could result in the lowest common denominator for rights. For example, the value of French films, which are very valuable in France but less valuable elsewhere, could be completely undermined if there is a system which allows those rights to be imported back into France at a seriously lower level. In addition, the window system whereby films or other creative products are released on a time basis. For example, films tend to come out first of all in cinemas, then on video, then on television. This system has not necessarily been threatened by the ruling. So I think looking at the creative industry as a whole, there was probably a bit of a sigh of relief when the actual ruling came out. But strangely enough, it may well be other sectors of the economy that will look at the ruling and get a little bit worried. And the reason is that Advocate General Cocotte, in her advisory opinion to the European Court of Justice, stated that the case could have an impact on a number of new economic sectors. And if I may quote her, she stated, "This impairment of freedom to provide services is particularly intensive as the rights in question not only render the exercise of freedom to provide services more difficult, but also have the effect of partitioning the internal market into quite separate national markets. Similar problems exist with regard to access to other services, for example, the sale of computer software, musical works, e-books or films via the internet. It may well be in the future that this is where the ruling will have its most profound impact." So all that taking into account, this is quite a dramatic potential change for a case that arose from a Portsmouth pub.
Beyond Meteorites then, Ben, have competition rules been applied to other areas of sport?
The competition rules have been applied to a number of other areas. Perhaps one of the more prominent ones is ticketing. For example, in 1999, the European Commission found that the ticketing sales system of the French Organising Committee of the World Cup, which was held in France in 1998, infringed EU competition rules. The reason why it infringed the competition rules was because the French Organising Committee put in place a ticketing system which was very biased towards residents who lived in France. The European Commission found that this element of the ticketing sales system was in contravention of the European competition rules. Now, this was the first case of its type, and the Commission only imposed a €1,000 fine onto the organising committee, which I doubt would even buy you a ticket to the final. As a result of this decision, a number of other ticketing cases have since come out, and organising committees of large sports events are particularly careful to ensure that the tickets are available on a non-discriminatory manner and to European citizens across the board. One element of this is that purchasing the tickets should be easy for consumers. What this means is that consumers in the United Kingdom are able to pay into accounts in the United Kingdom, whereas consumers in where I live in Belgium are able to pay into an account in Belgium without encountering any major banking fees, which is nice.
Ben, many thanks for coming through today to speak to us about the impact of competition law in the commercial activities of sporting clubs and organisations.